Hi everyone, my name is Nicole Slowey and I am the Operations Director here at Qdos. And in this video today, we're going to be talking about some recent MSC case activity. Now, it's been quite some months since we first reported HMRC's ramped up efforts in respect of MSC investigations. With those investigations, or the activity surrounding what could turn into investigations, what we have seen is HMRC targeting a couple of contractor accountancy firms and a number of contractors who have received services from those particular suppliers. Now, this case is actually a little bit different. In this scenario, Mr. Gradidge was taken to a first-tier tax tribunal. And what's unique about this particular case is that the tribunal wasn't actually there to establish if the legislation applied. That had actually already been established as part of some historic compliance activity back in 2015. What this case was looking to establish was whether or not the debt transfer provisions within the legislation could actually be applied in this particular scenario. Before we go into any more detail on this case just yet, I wanted to just spend a minute talking about the debt transfer provision that actually exists within the legislation. The MSC legislation is widely criticised, and for a number of reasons, but one of the key points of criticism is the extensive debt transfer provision that actually exists within the legislation. What that essentially means is it's not only the individual contractor and their limited company who are the recipient of the service from the MSCP who has financial risk, not only the managed service company provider who has financial risk, but other parties actually connected to those organisations in the wider supply chain actually have an equal risk as well. If HMRC concludes that the MSC legislation applies, the principal party initially responsible for the tax liability is the limited company the contractor provides their services via. If HMRC is unable to recover funds from the contractor's limited company, they have powers within the debt transfer provision to look to seek those monies back from the individual director of that particular limited company. And as I said before, that financial risk and liability can extend to the provider of the service, so in a lot of cases, the limited company's contracted accountancy firm, or actually the recruitment agency that engaged the contractor to provide the services to a particular client. And in a lot of instances, it's possible that that recruitment agency may have even referred the contractor to that particular accountancy service provider. That in itself brings to light the far-reaching risks that are associated to MSC legislation and why all organisations through the supply chain should look to establish processes and significant knowledge around the subject to make sure that they understand where the risks are and what their respective compliance obligations might be. In Mr. Gradidge's case, he was providing his services via his limited company, N19 Trading Limited. He was a client of an organisation, Think Accounting Limited, who provided Mr. Gradidge with advice and services in respect of setting up his limited company. Now, as I said before, it had been concluded in previous activities that Mr. Gradidge's company was in fact an MSC and Think Accounting was in fact an MSCP. So the key point of challenge in Mr. Gradidge's case was whether or not the debt transfer provisions that we talked about could actually be applied and see the liability transferred back to him personally as an individual. Now, as part of Mr. Gradidge's defence, he presented two main points really of challenge. The first being that he didn't appreciate and wasn't necessarily aware that he was actually a director of his own limited company. And second to that, and one point which is perhaps a little bit more technical, was that the debt transfer notice was actually presented when in fact Mr. Gradidge had resigned as being a director of his limited company. If we take those 2 points and go into them in a little bit more detail, a contractor who was a director and the sole director of their own limited company who wasn't aware that they were in fact officially a director may be surprising for some but not surprising for others. Now, it's not uncommon in the marketplace and perhaps was more prevalent historically, the individuals seeking particular opportunities and contracts were directed down the path of setting up their own limited company as a means to access particular contracts and opportunities. In this case, Mr. Gradidge actually stipulated that he had in fact been recommended to Think Accountancy Limited by a recruitment agency. Now we know that that isn't uncommon practice in the industry, but that actually ultimately became part of the contractor's defence to basically stipulate that he didn't really fully appreciate the specifics or the ins and outs of setting up a limited company. This really does bring into question a bigger issue that affects the market as a whole, and one which we have been frequent to comment about, in terms of contractors going into business in their own account and being wholly and fully aware of the responsibilities that exist when you are a director of your own limited company, the areas where you should have full control over how you're remunerated, how you're paid, and ultimately how your company is set up. So whilst this was part of Mr. Gradidge's defence and will ultimately get to the outcome, it's really important in a wider context for contractors to properly appreciate the ways in which they're engaging with their clients, the recruitment agencies and their professional services providers in the context of how they choose to actually deliver their services. Despite trying to use a more technical point of challenge where Mr. Gradidge and his advisors disputed the case because ultimately Mr. Gradidge was no longer a director at the time the debt transfer notice was actually issued. The Tribunal actually found in favour of HMRC because ultimately the debt was accrued at the point where Mr. Gradidge was in fact still a director of his limited company. In this scenario, Mr. Gradidge was unsuccessful in upholding the challenge that he was making around the debt transfer provision. That in itself is just another stark reminder for contractors themselves as individuals, in respect of the fact that they have their own limited companies, could potentially have a personal liability should the MSC legislation be found to apply. Now, as I said at the beginning of the video, this case is a little bit unique and not quite similar to those that we're seeing at the minute, because ultimately the decision around whether the legislation as a whole applied had actually already been considered. Now, in terms of key takeaways for contractors, as I've said, it's important for individual contractors to have a solid appreciation of how their companies are set up, the nature of the engagements that they have with their professional services providers, such as their accountancy firms, to make sure that you have at least an appreciation of the potential risks around different types of legislation, inclusive of MSC, similar to IR35 as well, where you need to make sure that you have a view of where the potential risks are and how it could ultimately affect your business. As with all first-tier tax tribunal, the actual full case detail is available publicly. So if anyone wanted to understand some more of the intricacies or the nuances that existed within the case, or just wants to see more detail in the case, this information can actually be provided for you to read at your leisure. As we've said before, we will look to keep you up to date as things change with the MSC landscape. In this case, it's a little bit more unique and not wholly reflective of the recent activity, but again, it's an important reminder to contractors in their capacity as individuals, but also the wider supply chain, of the far-reaching effects that MSC legislation can have. And another note that HMRC, whilst not publicly, has in fact actually been undertaking compliance activity in respect of the legislation over the last few years, largely going undetected. As with all of our videos, if you want to stay up to date with information from Qdos, please subscribe to our channel.